Good afternoon, everybody. Is this on? Yeah, it is. Okay. Many of you will no doubt notice that I am not Sue Hong. She had to run back to Judiciary and for some votes. I think she'll be back shortly, but she asked me just to sort of get started. So I'd like to ask Representative Crow to open us with a word of prayer.
Thank you, Mr. Chair. Bow with me, please. Lord, thank you for allowing us to gather here once again to take up the business of the people of the state of Georgia. Please guide us through these deliberations. Let everything we do be done in a way that's respectful and shows respect to each other and to you, Lord. Guide us, direct us, and be with everyone as we leave here today. In Jesus' name we pray. Amen.
Amen. Thank you. Thank you, Representative Crow. So we've got a pretty full agenda today. I'm going to go ahead and try to get started. I do note, though, according to Chairwoman Hong's notes, that House Bill 334 and House Bill 379 have been pulled from the agenda. So if you're here to hear those two bills, unless I'm in some way mistaken, I don't believe we're going to be hearing them today. So I'd like to go ahead and get started. 334 and 379. It's on the copy I have. Chairman Yurda's bill. But we'll go ahead. We are going to hear House Bill 332, which is Chairman Parrish's bill. So if you want to go ahead and present that bill to us, Mr. Chairman, just come on up to the podium. I don't think we've got a table for you.
Thank you, Mr. Chairman. Appreciate the opportunity to share with you quickly House Bill 332. This is the annual drug update bill that's requested each year by the Georgia Department of Drugs and Narcotics. For you that are returning members, you know this is basically a cleanup bill we do every year. To the new members, it comes to us from the Georgia Drugs and Narcotics in conjunction with the GBI to bring us up to date so that our state laws concur with the feds regarding to controlled substances. It just allows our law enforcement folks to do their job more effectively and more efficient. As far as I know, there's no opposition to it. It's strictly just a cleanup bill. Be happy to answer any questions, Mr. Chairman.
Thank you, Mr. Chairman. Do we have any questions for Chairman Parrish? Okay. All right, I don't see any questions. Do we have a motion?
Motion to pass.
Well, let me stop this. Is there anyone signed up to speak on this bill? Okay, I've been bad to jump the gun on that. All right, so I've got a motion. Do I have a second? Second. A motion and a second. Is there any discussion? All those in favor signify by saying aye. Aye. All opposed, like sign. The ayes have it.
Thank you very much.
Recommend due pass to the full committee. The next, Chairman Mathiak, House Bill 166. When you're ready.
Thank you, Mr. Chair and committee. This bill was brought to me by my magistrate in the Griffin Judicial Circuit. She still uses constables to deliver her documents, and she couldn't find anybody within our county. And the previous the previous law said that the person had to be from our county. What this does is take that out and allow the person to be from the judicial circuit. That's all it does.
So thank you, Madam Chairman. So is this, when you say, does the magistrate use the constable to affect service on people, service of process?
Yes.
Okay, I see.
Yes.
So she's just having trouble
finding an employee.
Finding them based on the restrictions of the statute.
Yes, sir.
I got you. So we're requiring they be 21, be a citizen, be a registered voter, and have obtained a state-accredited high school diploma or general education GED diploma.
Right.
And then we can impose additional qualifications by local law if the locality wants to do
right.
that. Okay. So we're just taking that away. It used to be the same as a magistrate, which required the residency requirement.
Right.
Okay. All right, thank you. Any questions for the chair lady? I hear none. Is there anyone here signed up to, oh, wait. Oh, yeah, we do. Oh, okay, all right. No, well, no, thank you. No one to sign up on this bill? No, okay, we don't have anyone signed up, so Chairman Crowe, if you want to go ahead.
Move do pass, Mr. Chairman.
All right, we have a motion to pass. Do I hear a second? I have a second, a motion and a second. Is there any discussion of the motion? All right, hearing none, I'll call for the vote. All in favor signify by saying aye. Aye. All those opposed, like sign. All right, congratulations. Ayes have
Thank
it.
you. I appreciate it. She does too.
All right. Chairman Saints, you're next on the agenda, House Bill 188.
Thank you, Mr. Chairman. House Bill 188 has been a labor of love. This committee has passed it, I believe, 3 or 4 times in the last couple years and brought it to the Senate. House Bill 188 was made necessary by Park v. State of the Georgia Supreme Court about 5 years ago. They made a decision that GPS monitoring could not be used as an effective tool to deter dangerous sexual predators if they were outside of a state statutated probation period. So what we do here, and over the years through input, we have very much restricted to the bill to who it applies to. But basically, as you go through the bill, there are 13 felony sex offenses that it would apply to, and it only applies to those individuals that would have been adjudicated once for one of those 13 crimes, and then again on their second offense, there would be a concurrent lifetime probation put in place to where once they're in probation, the state could ensure that they can be GPS monitored for life. I will go through it. There is it's a hefty bill, but most of it, in terms of what it does, goes through each of those sex offenses. So Section 3 all the way to, I believe, 313 on page 10 goes through those crimes. I would note there is a substitute available. It does several things, but a cleanup item that it will do is eliminate lines 223 to 226. This bill was drafted prior to that being effective into law already through a different act of the General Assembly last year. So in the substitute, which I won't refer since the committee doesn't have it, that will have been cleaned up. Appreciate that. In terms of, there's been a lot of conversations about judicial, what do you call it? Judicial, forget, when you let them make decisions? Discretion. I figured the audience, thanks for the phone a friend. It does require that this lifetime sentence be placed on those very restrictive cases initially. But if you look at the end of the bill, Section 6.4, it's where making sure Section 6.5, it ensures that not the individual on GPS monitoring or on life probation, but a Department of Community Supervision after 10 years would bring this before the state, and that's where the judicial discretion lies. It allows for the judge at that time to make the decision based on more information, specifically the SORB classification, the sex offender review registration board. Now this bill would also seek to make it a review board. There's some cleanup items in terms of SORB legislation in here that there hasn't been much issue with in terms of the administrative changes that SORB requested. I will say, in terms of a substitute coming forward, which we're not looking at now, but there might be some testimony from folks who are looking to speak. You have some, the committee has a purple packet that addresses the change that we're going to hope to make to the bill in the future to Merriam's Law. It deals with an individual that unfortunately became the victim because of a person who was sentenced to a felony sex offense. He was waiting for the SORB classification. We do know SORB has a huge backlog. It's been made even bigger. So the change in that substitute would seek to If you're a dangerous sexual predator, a level 3 so the most likely to reoffend, or if you're waiting for that SORB classification. So if you're waiting, you'd be put on GPS monitoring through your probation through DCS. And if you are then leveled a 2 or a 1, that GPS monitoring could be taken off, but it would be required for those level 3s. Right now, as a policy, we have 530 level 3s on through DCS, and 326 are electronically monitored. So it's not every individual. So it would be a policy difference there as well. But the most significant in there is those waiting that we do not know how high of a risk they are that they'd be monitored. With that, I'm sure there's some questions from the committee and possibly the crowd, so I'll stop there.
Thank you, Mr. Chairman. I did want to just make sure I understand the structure of the bill, and I think you were explaining this. So Section 3.1 is where we actually define the sexual felonies that when either you don't have to repeat the same one. If you commit one and later commit another within the time period, it would trigger the protection.
Yes, Mr. Chairman, it's the bad menu of felonies that if you have one, then do another one, it doesn't have to match up.
And it looks like what we're doing is we're going through and amending each of the penalty provisions and each of the statutes concerning those crimes to make it clear that that these protections can apply. So it's throughout the code.
Anything to add, Pages?
Okay. What's that?
Nothing, Mr. Chairman.
Okay. All right, do we have any questions of Chairman Saines from the members of the subcommittee? I see one. Is that Representative Byrd?
Thank you very much. Am I seeing here that we are changing the name from the sexual registry? Could you explain to me why?
Thank you, and I apologize for skipping that. It's a SORB request. I think there's some public confusion on what SORB does. So they right now they don't do anything in terms of registration. That is the domain of in terms of making sure that the registration list is active and being monitored. That's a responsibility of the county sheriff. SORB only levels individuals that are sex offenders in terms of how high risk they are. So they want to make sure that their name is more closely aligned to what they do. So that's the distinction between the registry review board versus the, let me make sure I'm saying it correctly, risk review. So they're reviewing the risk of that offender.
Further question. So are we having two different organizations for a sexual registry, or we're eliminating, just changing the name?
We're just changing the name. We're not creating a new agency. We're just aligning the name of the agency more closely to what the responsibility, and we're not changing the responsibility either.
Thank you.
Thank you, Representative Byrd. Representative Miller?
Thank you, Mr. Chairman. Just a clarification question. So if a person the law right now is that if a person is a sort of level 3 dangerous sex offender, they have to wear an ankle monitor.
Based on discussions with DCS, that is not a perfect parallel. The majority of level 3s are on GPS monitoring based on the statistic. Again, 530 are leveled a level 3, but only 326 of those are on GPS monitoring. So and I'll let them clarify but currently my understanding is no, it's not a perfect requirement in terms of a level 3. So that would be a policy change.
Okay. And then as it relates to the level 1 and I guess 2 folks, so is it accurate to say person who, let's say, is a level 1 person but has not yet been designated a level 1 person, they are released from prison back into the community to be supervised by probation? As it stands right now, they would have to, with this bill, they would have to also be fitted with an ankle monitor, and then until such time as it can be determined that they are a level 1, a level 2, or a level 3. That's
correct, and I think the policy distinction here, as a scale, are we going to put the onus on the individual who has committed a felony level sex offense or a sex offense on reducing the risk of the possibility of them being a level 3, or are we going to put the weight on the public on taking the chance that they could be, but we're not going to put that restriction on them? So this would put the onus on that perpetrator instead of the public.
Understood. And one more follow-up question, Mr. Chair.
Yes, ma'am. Sure.
So what would the average amount, let's say a person has been convicted of statutory rape, and they would, once they've been assessed, be a level 1 risk to reoffend, for example. That person under this bill would be required to wear an ankle monitor until such time as they've been assessed by the risk review board. How much time on average would it take for individuals who otherwise would not be forced to bear the expense of an ankle monitor? How long are they waiting for that determination to happen?
I know it's been made longer. There's not a perfect. If I'll ask, in case there is someone who can better answer that, is any representative from SORB here? I do not see. Okay.
Someone signed up.
So if you're okay with it, I don't have that statistic and I don't want to give you an inaccurate one. So I'll ask her to address it during the class, during her testimony.
Fair. And if a person, let's say a person who's a level 1 who once they've been assessed would not have to bear that expense, are they then held in custody until they can afford to come up with an ankle monitor? So in other words, would it prolong their release date if they could not afford an ankle monitor to bear the cost of that?
I wouldn't, in terms of because we're going into very specifics on a substitute that we don't have, the committee doesn't have in front of it. I'll hold that question, that I'll verify that, but I don't want to go too much in the weeds of a substitute that I just kind of wanted to preview for the committee.
Understood.
Thank you.
Any further questions, Representative Miller?
No, thank you,
Okay.
Mr. Chairman.
Thank you. Any other questions of the sponsor? All right, why don't we get to some of our witnesses? Let's see, where are we? Thomas Weaver. I'm using your copies if you want them.
Thank you, Mr. Chairman, for recognizing me to speak, members of the subcommittee. I respectfully request, since we're working off the current version, this current LC printer number, I don't have access to the substitute like Representative Saint said, so if everyone here, if it should meet with your approval, could I invite everyone to please turn to page 11 and look at lines 249 through 251. The entirety of Part 6 of Section 6-1, well, there's other amendatory language under that section, but I want to focus like a laser on those lines, 250 and 251. Last year, I was successful, and others, in the Georgia Senate Judiciary Committee in removing the language that this measure seeks to add into the current law. And I respectfully request that this subcommittee recommend to the full committee to delete this proposed modified language, and I'll provide you the statutory reason why. As a matter of kind of like a historical note, it was under Section 4 of Senate Bill 117. That was the bill, if you recall, for those members who were here, that was the one about the foster, first and second degree, foster parent, foster child. Well, electronically furnishing obscene material to minors in violation of current Georgia Code Section 16-12-100.1 under subsections C and D of that code section are misdemeanors. Under the current language of Georgia Code Section 42-1-10, subsection A, paragraph 10, subparagraph capital C, any misdemeanor offense or any offense that is adjudicated through the juvenile court is statutorily excluded from registration requirements. Because this current code section is not amended under the bill and it remains a misdemeanor, even if this proposed law were to receive gubernatorial ratification, my fear is that if an individual were to be lawfully arrested for, duly charged with, and properly convicted of a violation of only this code section, based on the proposed amendment here, the judicature, the judge that's presiding over that case, based on this amendment, post the effective date, would be required to sentence that criminal defendant as a portion of the sentence to the registration requirement that the General Assembly seeks to add through the modified language here. However, the criminal defendant by and through counsel, I think, would be able to object and appeal on the basis that, based on the way that the law defines a sexual offense, is exclusive of misdemeanor offenses. Regardless of however a criminal defendant is arrested, charged, or convicted for one of that particular code section, there's no felonious sanction. It's always a misdemeanor. So, because the law says what it says, and A10 capital C, rather, is not touched under this bill, I would respectfully request that this subcommittee make a referral or recommendation to the full committee to strike lines 250 and 251 from the bill. And I'm happy to take any questions if anyone has any.
I did have one. So you're saying the fix would be striking all that language, not narrowing the cross-reference? In other words, is there no felony within 1612?
There's, Mr. Chairman, there is no felony crime under 1612-100.1. Georgia Code Section 1612-100 through Subpart 3, that's point 1, point 2, and point 3. It encompasses that article of the law under that chapter, but for one of this particular code section, it's always a misdemeanor.
Okay.
So,
Representative Crowe?
That was my question too.
Oh, okay. All right. Well, I guess as we do have a sub that's going to be presented, we're probably not taking action today, so that's something we may want to have let council check on for us to see. Thank you. Did you have anything? I didn't mean to cut you off.
no, Mr. Chairman. I'm just thankful that the subcommittee is amenable to directing legislative counsel to ensure that that matter is professionally addressed as a matter of law.
Certainly. We appreciate your comments. Let's see. All right, I'm sorry. My eyes are getting old. Tracy Alvaro, and I can't really read the last, with Sorb. When you're ready, just
Thank you, Mr. Chairman.
identify who
and
you
the
are and
subcommittee.
say your name correctly so we all know, since I
Tracy
can't.
Alvord. You're close.
Alvord.
And Marcus Beagle.
Okay, thank y'all.
I have him here as my research expert. I'm not sure how much as Representative Sain said, we've been through this 3 times through the House. And so I don't want to take up too much time, but I just want to reiterate some things I think are really important in this bill and why this bill is so important. I am not familiar with the substitute, so with Merriam's Law, so I can't really speak on that, although I can answer some questions that you might have about SORP and our backlog and that type of thing. So I'm a very visual person, and I like to provide visuals to people because it makes a lot more sense than just people saying things. And so one is I thought it might be interesting for y'all to have the Parks case. The Parks case is the one, of course, that Representative Sains mentioned, is what resulted in them overturning our ability to monitor predators once they're off of supervision. And so hearing about it versus knowing the depths of what this man did is very, very different. So it's good nighttime reading. So good luck with that. The other thing is that when there's been testimony previously in past years, there's been examples that are given that are actually not related to this bill. And so I want to clarify an actual example of a situation that is directly related to this bill. So if you have somebody who has committed a sexual offense one time and is convicted of that sexual offense one time, that doesn't mean they fall under this bill. And there had been an example given about a teacher who had sex with a 17-year-old student on student grounds that was not their student, and how they would have to have a lifetime of supervision, potentially incarceration. But that's not true, because that individual, that'd be their first time offense. And they would not have their teaching certificate after that, so they would not be on school grounds again. What would have to happen, what has happened and can happen, is if that individual then later went on to commit another offense outside of the school grounds with another child or an adult that's a felony sexual offense. And then that person would then fall under this particular law. what we find is that the most predictive risk for recidivism, if somebody commits a sexual offense, is caught, is prosecuted, and then they go on to do it again. So if you really think about it, if somebody does something and then they don't do it again and they do what they're supposed to do, and which is what we expect of them to do, but then they go on to continue engaging in the same kind of behavior that got them in trouble the first time, there's a serious problem, and they're seriously dangerous, because clearly they haven't been able to stop the behavior, because now they're charged and convicted again. So I have an example, because statutory rape cases come up a lot, and I understand that, and I think that I think we all definitely have a heart for our young guys who are in school with, you know, older teenage girls, and they get convicted of statutory rape. It's a really difficult case, and I'll tell you, in the majority of those cases, the individual may be prosecuted as with prison time, but most of the time we see them with probation and first offender status. So they're able to come off the registry, they're able to do whatever. In this case, I'm going to give you an example. The individual actually was a statutory rape case, but he was 29 and she was 15. We see that more often than we do see the younger folks. So we see older men having sex with teenage girls or teenage boys, and they're being prosecuted with pleas of statutory rape, which we know how that goes with court. So in this particular case, we classified him when he got the statutory rape case, and he was labeled as a 1. So he would not fall under this law. It would not apply to him, and even though he was 29 and she was 15. However, 8 years later, he gets charged with a new offense of sexual exploitation of children with a 10-year-old child. At that point, we made him a predator. And so it kind of shows you the dynamics, and he would fall under this law. Right now, for this individual, because we made him a predator in 2020, he'll come off the monitor at age 58 because he will no longer be under supervision at that time. So I'm going to just for your example. So I just want to give you a clearer example of what that looks like. The other thing that I want to give you an example of is that one of the questions is the 10-year rule. Like, how did we come up with, once the offender has been under supervision for 10 years, why is it 10 years to say they should be reviewed again by the courts and potentially come off of supervision rather than be on life supervision? And when we look at the research, which if you have questions, Marcus can answer, but when we look at the research, 10 years is really a good time frame to say that this person has, if they have consistently shown us a behavior that is suggestive they have desisted from sexual offending. And I have a very small group of, so with SORB, we get notified when we're supposed to by the clerk of courts when somebody's been convicted of a sexual offense. So I keep track of those who have been classified and then reoffend, and then we have to classify them again. And what I found in my very small sample of 61 sex offenders that we have classified and then they've reoffended is about 75% of those that reoffend is later than 5 years since they've been caught the first time. And then actually it was 56% that sexually reoffended 8 years after they were caught for the first time of committing a sexual offense. So really 10 years is really honestly the minimum. We had looked at 5 years and I didn't feel like that was enough. I think 10 years at least gives us an idea how this person is. I'm giving you my printout of that. The other honestly is research-based. I don't know if you want it or not. I'm more than happy to provide it to you, but it explains why the 10-year mark is probably the best option when it comes to really feeling secure that this individual who is a predator or has at least 2 separate sex offense convictions could be considered for release from their supervision. And I think that's all that I have. I could answer your question now regarding our backlog, if you'd like me to do that. So I hate that question, just saying, because we have I have 4 clinical evaluators. There are 32,000 sex offenders on the registry, just to give you an idea. There are currently approximately 150 brand new sex offenders coming into Georgia or coming into where we would level them every single month. Between 35 to 65 new out-of-state sex offenders move into Georgia every single month. And then the rest of them are being released from parole or onto probation or being newly sentenced. And so it's a huge number. So even for us to keep up with the current number of cases that we get each month is difficult, let alone tackling a backlog that started when SORB was first put together where there wasn't even any staff. So it probably was about 2 years when SOAR was implemented in 2006, they really didn't start getting, because they had to do policy and put everything together. So it probably took about 2 years for them to start cases. And they only had at that time 2 part-time evaluators, no investigators. And so the evaluators had to obtain the criminal documentations themselves. When you look at those SOAR reports, you see the extensive amount of information that we go through. So our process is very different than, let's say, Florida. Florida does a tiering with the Adam Walsh Act, where they're tiered 1, 2, and 3, 3 being the most dangerous. They do it based on conviction alone. And research shows that actually it's inverted. So if you see somebody from Florida that's a tier 3 who's supposed to be a predator, they're actually probably more likely a 1, and then vice versa with the 1 with being a predator. And it's because it's based on conviction alone. We look at everything in their criminal history. We look at their entire community supervision. We look at their entire prison situation and their behavior in prison, and we look at treatment records and that type of thing. So we're doing a very extensive review of how their behavior is to determine that. In addition, if we have an offender who, let's say he's on probation, he's acting out, there are options where the DCS officer may request for him to be reviewed again due to concerns of his risk. So that will happen. We get court orders. So there's a lot that goes into this process, and we've got 4 evaluators to do all this. So the answer to that is we have no idea, unfortunately. We could have a situation where, let's say, Hall County cases. So oftentimes my investigators will go to Hall County, collect all the documents for all the Hall County convicted sex offenders and get that. And then they'll go to the next county. So I currently have 1 full-time investigator and 3 part-time investigators. They also have to deal with not only, so when you look at those criminal records, we may have a guy who has 3 pages of criminal records where they have multiple violent offenses that we have to research. They have multiple states or counties we have to research. They have multiple sex offenses we have to research. I actually gave you probably 2 of the lower level predators. When I say lower level, what I just mean is, we see things that you see on TV that's very, very scary. So getting all that information, putting it all together, having the very few people that we have to do that, it's kind of luck of the draw. We do try to identify immediate priorities as quickly as we can. So if we get their criminal history and we see that they have 2 sex offenses, doesn't matter if they're convicted or not, but they have 2 separate sex offenses, we immediately try and process those cases because we already know that they're higher risk for sure. If we don't know that, then we're not processing them more quickly. If DCS, or the Sheriff's Department, or Pardons and Parole, or somebody, the public, if they contact us saying, we think this guy is really high risk and this is why, we will immediately prioritize that case. We have a problem with out-of-state sex offenders coming to Georgia wanting to come off the registry, which is one of the things we're trying to deal with. Representative Ballinger's bill is to not allow that to happen anymore because they're bogging down the system dramatically for SORB and for Georgia. We're dealing with these guys who just want to come off the registry, and because it's a court order, we have 90 days to get it done, and we have to do it. And so that bogs us down too. So long answer for a question like that, and it's just not an easy answer, unfortunately. I wish I could tell you it's a lot quicker, and we probably wouldn't even be having this conversation.
Thank you. Representative Miller, do you have a question?
Thank you for that answer. I appreciate that, and I sympathize with what you are being tasked with, and it sounds like you are underfunded.
Yes.
Can you speak a little bit about what you think it would take for you in terms of funding to effectively do your job in terms of quickly processing these, figuring out the people who need to be monitored most intensely? Can you speak to us a little bit about that?
So we currently receive a little over $900,000 from the state and a little over $200,000 from the feds in a grant that we have with CJCC, which we pray every day we do not lose that grant because it's from year to year. If we lost that grant, we would only have enough money for 1 investigator. So if you put those 2 funds together, if you double that, that would make a dramatic impact in our ability to process those cases, because that would give us 8 clinical evaluators, that would give us more like full-time investigators and some administrative staff.
One follow-up, Mr. Chair?
Yes, sir.
Thank you. So I just want to make sure I'm really clear in understanding how we're differentiating between some of these folks. So if we use the statutory rape example, the person has been convicted of statutory rape, has gone to prison, and they are now being released to serve out whatever balance of their sentence is probated. would that person would have to be assessed by the review board in order to determine whether they are risk 1, 2, 3. That is accurate, correct?
That is right.
Okay.
Yes.
And so I know we cannot pin down an average amount of time, but let's say we're talking about that first offender who is scheduled to get out, and who perhaps may not have the money that under this bill to afford monitoring monthly. Can you give us a ballpark amount of time that this person might have to stay in prison because they can't afford an ankle monitor, for example, first-time offender, and who will probably be a level 1 risk once you have the opportunity to assess them?
Again, I'm not familiar with the substitute, so I do know that, so let's use proximity as an example of that instead, just because I'm familiar with that, how that works. So you might have an offender who has nowhere to parole out to or max out to. If somebody doesn't have somewhere to parole out to, then they remain in prison until they do have somewhere to parole out to, or they're homeless. If they're maxing out their prison sentence and coming out into supervision, they get out of prison, so they don't stay in prison. So I can't imagine that if a person couldn't afford their monitor, and again, I'm just it's hypothetical because I don't know about the bill, but that they couldn't keep them in prison if they've maxed out their sentence. I don't know if that answers your question or not. Yeah. You're welcome.
Thank you, Representative. Do we have any other questions for this witness? Oh, there is. All right, sorry, Representative Byrd.
Thank you very much. I appreciate that. Is there any specific reason why sexual predators are at large numbers coming into the state of Georgia? I mean, you're saying there are a lot of moving into Georgia.
Yeah.
Could you explain to me why that is happening?
No, not necessarily predators, although I will tell you that Florida, they're all predators based on the tiering process and how they do it. It's because they're able to come to Georgia and get off the registry. Or I should say, they're coming to Georgia and requesting to be removed from the registry. It is, of course, the judge's decision if that happens or not. But in their state, so for example, in Florida, I believe a predator, I think it's a minimum of 25 years on the registry, if not lifetime, I'm not sure. But in a lot of states, it's lifetime registry. Georgia used to be lifetime registry, and I've spoken with a lot of states who are trying to change some of their laws because and replicate Georgia because the way we do things is more constitutional, I believe. And but because they have to be lifetime in their state, or because they have to be 25 years in their state, and they know Georgia, they could come off as soon as they come here potentially. They're going to come here, and then they petition the court in the county that they're living. Then they have us classify them, and that they're level 1, the judge can choose to remove them from the registry. And so they're aware of this, and news in the sex offender world travels very fast. It's quite amazing how that works. So.
May I have a follow-up?
Yes.
So if someone from Florida has a level 3, they move into Georgia, they go to through the court system, and it's a possibility that the judge will lower it to like a level 1, or how does that work, please?
Yeah, so if they come to Georgia, the sheriff's departments, and we had a conversation with GBI and the sheriff's department, so they don't really put a classification for them in our registry because they come from a Adam Walsh case. And so we don't want to misrepresent their risk. So the judge would then order for them to be leveled. If we have not leveled them yet, we would level them. And then if they're a 1, they'd consider it. If they're a 2 or 3, they would not. Or they're not supposed to. You're welcome.
All right, thank you. Any further questions? All right, thank you. And
Yeah,
were you
thank
going
you.
to speak as well?
No.
Okay, all right.
But no
Okay.
questions about research, so.
Okay, all right.
Thank you.
Thank you very much.
I appreciate it.
All right, I'm going to butcher the name, so you'll have to correct me. Ali Abdul Rab? Abdul Rab?
Yes, sir.
Abdul Rab. Thank you. Please come forward. Let's go to the podium there, and when you're ready.
Thank you, Chairman. Also want to thank Representative Sains for letting me come up here and speak on the bill and share my personal connection. My name is Ali Abdurrab. My sister, Miriam Abdurrab, on the early morning of August 13th, 2021, was followed home and kidnapped in front of her house and murdered the same morning. Shortly after that incident, we found out the individual that committed that crime was an unleveled sex offender who therefore wasn't monitored properly. Eventually, we realized why he wasn't leveled was because of the backlog that SORB faces, still currently to this day. I just want to come up here and show my support for this bill, just because knowing if this bill passed or has been a law, my sister would still be here today. But since that day, we actually, I'm here with my colleagues that have been helping me ever since. We've created policy initiatives that help with the backlog that SORB still faces. And it requires all sex offenders that are convicted of sex offenses to be monitored until they receive a risk assessment. If they are deemed a sexually dangerous predator, which is the highest level, they are required to keep the monitoring device until their sentence is over, where I guess they could apply to remove it. Thanks again to Representative Sains for letting me come up here, and I appreciate the subcommittee for listening. Thank you.
Thank you for your testimony. Does anyone have any questions of the witness?
I'll take any questions if anybody has any.
Doesn't look like you have any. Thank you very much. I know.
Yes, there's something I wanted to say. I have been watching videos of the Public Safety Committee and in the Senate, and they actually had a chief officer come in, and something that he said that stuck with me is the oath to protect is bipartisan, and that's exactly how I look at this bill. So it serves the same purpose to protect the people in our state. So thanks again for your time.
Thank you for your testimony.
Thank you, Chairman.
Jill Travis with the Georgia Association of Criminal Defense Lawyers.
It's weird seeing y'all over here trying to get the perspective. Good afternoon. My name is Jill Travis. I'm with the Georgia Association of Criminal Defense Lawyers. Chairman Sains and I go back a little ways on this one. But many of you haven't been here for all of the hearings, and so I want to give you a little bit of background as to what's in this bill. And I'll just say this. I'd like to put a pin in this idea that's being kind of talked about in the substitute. I can't talk to you about what's possibly in the substitute, and so I probably would have more feedback on whatever is in the substitute once we see the language. What I would like to talk to you about today is House Bill 188. How'd we get here? Well, in 2019, there was a Georgia Senate report. It was the Senate Study Committee on Protections from Sexual Predators. And they reached it's on file in the Senate. And they studied this issue. And they had testimony from PAC, GBI, this is a weird microphone, Department of Corrections, DCS, SORB, and GACTL all had input in making the report. And obviously it's 11 pages, so I'm not going to go through it, but the conclusion that I want to be clear about was the study committee recommends legislative action to give judges discretion to include lifetime GPS ankle monitoring, to give discretion to order lifetime monitoring, and to have people's leveling information from SORB available at the time of sentencing. That's what the federal system does. Part of that is in Chairman Sains' bill. The part that's not in there is the judicial discretion. the having the leveling information available to the judge in this circumstances is in the bill, and we appreciate Chairman Saines's inclusion of that. The other thing that Tracy has provided to you, the nighttime reading of the Parks case, is for those of you that are lawyers on the committee, you would understand the issue of due process. You can't impose a sentence you can't impose punishment after the sentence is ended. And that's what happened in Parks, as his sentence was ended, and so therefore you can't keep going on with that kind of punishment. The other thing that I think that those of you that are lawyers on the committee will recognize is that many of these offenses already carry lifetime punishments for second offenses. Find my chart here. One of these pages. I'll come back to that. So, specifically with regard to this bill, some of the things that we would ask the committee to take into account are, number one, Mr. Weaver. Mr. Weaver is right, so we'd ask you to please make that change. He can recite the law better than I can, and he's absolutely 100% right, and appreciate that. He picks up on things that sometimes we don't always see. The other thing that Ms. Alvord referred to was the scenario with the statutory rape and the first crime that happens. It is true, this bill only pertains to somebody who has committed a second offense. And the thing is that kidnapping with somebody with under the age of 14 already carries life without parole on a second offense. Rape is life without parole. Aggravated sodomy is life without parole. Aggravated child molestation is life without parole. Aggravated sexual battery is life without parole. So to the extent that I want to draw your attention, because this language keeps getting repeated on many of the lines here. If you just turn to page 4, if you're looking at, I'm looking at LC 480724, the filed bill. The sentence structure begins on line 66. And what it does is it removes the judicial discretion from the judge by saying that if you've been previously convicted, the person shall be punished by imprisonment for life, or a split sentence that is a term of imprisonment followed by probation for life. And goes on to say on line 69 that as a condition of probation, the court shall impose the requirement of electronic monitoring. The problem with this kind of assessment is it's only based on the name of the crime that is charged. It's not based on the personal attributes of the individual. I can imagine, I'm not going to stand up here and say that somebody that's been convicted of rape that has gotten some kind of lighter punishment and has gone out and committed another rape should get some kind of break. I would hope that the judge would impose a punishment that fits the crime. But to require the judge to have to give a life sentence when he doesn't all the way otherwise required to do that, and also the lifetime monitoring, we would ask that you change the word shall to may, and I'll read it out loud so that it's in the record of where we like you to make those changes. Some of these crimes, like enticing a child for indecent purposes, again, I'm not trying to say that any of these offenses are good. Any kind of violation of the crime is dangerous. But enticing a child for indecent purposes can also be done in a sting operation, where there actually is no actual person who's injured. Does it make it right? No, it doesn't make it right. But it's also what you're asking the court to do is to impose a life. And again, to be clear, this would have to have been the second time. They may not have done the same crime twice, but it's the second offense. to require the judge, without being able to have the proper information, to absolutely 100% have to give a life sentence without actually considering the circumstances, we would ask that those words be changed from may to shall. The other thing I think you also need to remember, although Chairman Sains is referring you all to the language that is on section 6.5, pages 18 and 19 on the bill, that this kind of the release valve to let people out after 10 years, whatever the amount of years is something for you all to consider. Certainly you've heard testimony on that. But what you have to consider is that release valve is not going to come into play until they've served, if they got a life sentence, they have to serve 30 years in prison. So this is 40 years later that this release valve is coming into play. It's not 10 years later. And that's not to say that somebody that hasn't spent 30 years in prison might not need some time in society to understand, but it also, the way that it seems to be presented as like, oh, well, they can get out after 10 years, they can come out from this monitoring. It's not that simple. It is a really long time to spend. The other thing that hasn't been mentioned that I'd ask the committee to consider is the references to improper sexual contact by an employer or agent. There's that's the common way that we think about this is teacher sex crime. I mean, or foster parent sex crime has been recently added, or employer, probation officer, and probationer crimes. I mean, obviously we know the authority that somebody has over someone else is high, and you shouldn't be having sexual relations with these people. However, the bill, I'm looking at lines 59 and 60, and it's elsewhere in the bill, includes first degree and second degree. And first degree, it would be having sexual relations and all the things that come along with that. I'm not going to go into the explicit nature of it, but second degree is just sexual contact involving the intimate parts of either person. And that carries a punishment of high and aggravated misdemeanor. And if the child is under the age of 16, then it carries 5 to 25 years. And now we're going to make it life for the second offense. Again, there's no way that I'm going to convince myself or any of you that it's proper. So, as you ponder a substitute, Mr. Chairman and members of the committee, we would ask that you take out the references to second degree improper contact. I know it's at lines 176, lines 59 and 60, but I haven't done a complete scan of the bill. We'd also ask that the shall be changed to may, and I'm going to name the crimes and the line numbers. Aggravated assault on line 67 and 69. Let me do it this way. We'd ask that the electronic monitoring always be a may, just to give the judge discretion. We elect judges to do the right things, and we hope that they would do the right thing, and in the proper circumstance, the person can get off, but they don't have to. And you can't just say this name of this crime means that this person is awful for the rest of their life. So I'm just going to name off the lines for changing shall to may for lifetime monitoring, and those are lines 69, 88, 110, 121, 131, 141, 153, 164, 178, 188, 198, and 221. With regard to the life sentences, we would ask that you change those on the crimes that do not already carry life sentences. And that would be aggravated assault with the intent to rape. That's at line 67. Trafficking, line 108. Statutory rape, line 140. Enticing, 162. Improper sexual contact, line 176. incest 186, and sexual exploitation of children at line 219. The thing to remember with Park is that he was classified as a sexually dangerous predator. And when you look at the statistics, you've got 32,000 sexual offenders in the state, and only 530 of them are classified as a level 3 right now. It's a small amount. But what you do with this bill is you make everybody that's committed a second offense level 3. That's the difference. You're requiring lifetime monitoring, and you're requiring a life sentence. Those are very serious consequences. We have confidence that our judges can do the right things in these circumstances. Happy to answer any questions you have.
Thank you, Ms. Travis, and thank you for your testimony. In terms of, you made several points. I want to go through one or two very quickly. In terms of the Senate Study Committee, I appreciate you bringing it up and recognizing the change in having the judge that information. You mentioned that the recommendations was to give judges the option of that lifetime sentence or lifetime GPS monitoring.
Yes, sir.
Would you agree that? And I would give to you the fact that it is not immediate. But the bill doesn't give lifetime GPS monitoring without a pathway for there to be a judicial discretion 10 years after the GPS monitoring section, after the probation section, for that review to be done based on the evidence presented by SORB on when the best time is to make that discretion on risk. Would that be a fair characterization of the bill?
I'm not going to say that I'm ungrateful for the change that you made and the inclusion, and I'm totally grateful for that escape valve. I just don't think that it has the meaning that you're trying to ascribe to it.
Okay.
And that's why I think the may to shall on the lines on lifetime monitoring would give the judges the proper discretion.
Thank you. You also mentioned the bill addressing charges and not personal attributes. In my perspective, and let me know if you disagree, if an individual, for example, raped multiple times or committed the act of child molestation, I would assume that individual is a molester, a child molester, a rapist. That becomes a personal attribute. Would that not be a fair distinction as a policy perspective, that those heinous crimes do become personal attributes?
Absolutely, in the sense that well, first of all, there are already controls in the law. So somebody that's convicted of a felony once, that's convicted of a second sexual offense, already has some things in the law that the crimes that I didn't ask you to change shall to may on, that's already covered by the law. What I'm saying is, and I've never been a prosecutor. I don't know enough about how the charging instruments would work, but I can tell you that there's behavior that goes on in the sexual arena that can be charged multiple ways. I would say rape is probably an exception to it, although even on rape you could charge child molestation because some of the elements might be easier to prove in that particular instance. But there are so many available crimes, and especially to your point, Chairman Saines, that if somebody is a repeat offender, and I don't mean repeat going through the court system, I mean has done this kind of conduct either over and over again with the same victim or with multiple victims, there are multiple counts that can be charged, and that person can spend the rest of their life in jail just under the penalties that we currently have. That's the thing, is that it's not like we don't have the penalties out there for these crimes.
Thank you. Final question, if it's okay with the chair. I noted the request to take out second degree from improper sexual contact. I noted modifying shall to may on the charges you mentioned. I think there was another request.
The the shall to may on the lifetime monitoring.
Okay. If those requests that you're making were changed in the bill, would your organization be in support of this legislation?
No.
Thank you.
I mean, well, let me say this. Would we jump up and down? No. Would I come back and testify? I would say we would be neutral to it at that point. But can I come in here and say that we're going to support it? I don't think that the answer to that is yes.
Any other questions for Ms. Travis? I don't see any. That's it. Ms. Travis, thank you very much.
Thank you for your time.
Help me see here. All right, I believe that's all the witnesses we have on 188. Is that correct? I haven't missed anybody? All right, my understanding is we have a substitute that's being formulated or that needs to be considered. We just want to, I think, do a hearing only today on this so we can get that out and let people comment on it and then bring it back. So I think we'll just consider this to be a hearing only on this bill, so we won't actually take a vote on it. But I do understand there's a substitute that we want to get distributed so we can take action on it as soon as possible. All right, is the next bill mine?
Yes.
All right. So if you'll excuse me, we have to do the fruit basket turnover here.
All right, thank you, Chairman Leverett, for filling in, and you are on the hot seat for your next bill.
All right, thank you, Madam Chairman. All right, I guess, today I quoted one of my favorite Yogi Berra quotes. It's like deja vu all over again. I know members of the committee are starting to feel that way about House Bill 227. This is the critical infrastructure bill. I suspect also you're probably about the point where you're like Jerry Clower, shoot up in amongst us. One of us got to have some relief. I'm hoping we can bring that to you today. We have another committee sub for House Bill 227, which is LC 480867S, which I believe is in your packets. So we kind of went back to the drawing board again on this bill to try to come up with a draft that address the policy goal that we had, but also hopefully did no harm to the integrity and clarity of the criminal code. So what we've done is we've incorporated the definitions that we need for this statute into the statute itself, and that all occurs in Section 2. And we've got some definitions in there, and I do have some proposed changes because we're kind of running on a tight schedule here, and I wasn't able to submit the substitute for review by Ms. Travis and Mr. Smith until just right before the meeting, and they had a few changes they want to recommend, and I'll go through those in a second. But we've tried to, there was a concern about eliminating the force or violence requirement from criminal damage to property in the first degree. And so what we did is we have reinserted that, but added an alternative charge for that crime, which would be you can knowingly and without authority and by either force or violence or by electronic means interfere with the proper operation of any critical infrastructure or any vital public service.
Chairman Leverett, and I apologize for interrupting. Our copy is just 2 pages. I'm assuming it's more than 2.
Yeah, it was 2-sided copies.
Okay, yeah, ours is just 1-sided, 2 pages.
All
So
right,
I
so
think
what-
we're missing.
Would we like to go ahead and maybe make those copies? I don't know if you've got one more bill on the
We
agenda.
do, yeah. If we can, we'll just suspend for a minute. I believe Representative Hilton should be here.
He's over
And so
there.
we can go ahead and hear his, and then let's
All
get
right.
your copies and go
All right,
back.
if you don't mind, I'll try to help get those copies run.
Thank you, Chairman. And Representative Hilton. Thank you for being here, Representative Hilton. If you can tell us your bill number and tell us a little bit about your bill.
Great, thank you. Thank you, Madam Chair, members of the committee. I'm here today to present to you House Bill 217. I'll be reading from LC 480749. Like many of you, this bill deals with the act of cockfighting here in Georgia, game cockfighting here in Georgia. And like many of you, I was surprised to learn that Georgia is the last state to to outlaw the act of game cockfighting in our state. As I said, Georgia is the only state in the country that does not have it. Animal fighting, more broadly, cockfighting, is illegal at a federal level. And I've got someone here who will testify in regards to the difficulty of prosecuting under that, but it is outlawed in 49 other states. State laws are necessary because the federal resources for investigation and prosecution of animal fighting crimes are typically limited to large-scale, multi-state operations. And I think all of us here would agree that we do not want Georgia to become a refuge or haven for this type of sport in our state. What really got me intrigued or interested in this subject is that it's never really about the animal fighting itself. Animal fighting is almost always associated with illegal gambling, drug trafficking, and other illicit activity that takes place around it. In several states, and Jessica Rock here with the Prosecuting Attorney's Council will testify as well, animal fighting rings have almost always been linked to cartels and other sources of human trafficking activity. And so the act itself is horrific, but I would submit to you that the public safety argument of the surrounding activity is almost as bad. And this gives us, again, another tool in our toolbox to prosecute Mexican cartels and other gang activity that's taking place right here in our state in Georgia. The underground shipping and transport of gamecocks across the country, again, to Georgia, represents another issue in our state. One of our states, our state's largest industry is agriculture, and when you are shipping back and forth animal that can spread disease and pose a threat to really our state's largest industry. And so for the public safety reasons, for agriculture, I think it's high time for Georgia to finally close the loophole, be the last state to put this to bed and make outlaw the act of gamecock fighting. So with that, I'm going to turn it over to a constituent of mine, Jessica Rock, who is a prosecuting attorney with the Prosecuting Attorney Council, who prosecutes these types of cases and can bring you some direct experience and her advocacy for this legislation. Thank you.
Good afternoon, everyone. I want to thank you for allowing me to come speak and for having this hearing and allowing me to talk to you about why we need to pass this bill in Georgia. Like Mr. Hilton mentioned, my name is Jessica Rock. I am the state animal crimes prosecutor with the Prosecuting Attorney's Council. Georgia is the third that I know of state in the United States to actually fully fund a state animal crimes prosecutor. I am also the very first federally sworn Special Assistant United States Attorney handling federal animal fighting cases in the Southern District of Georgia, the very first of its kind in Georgia and the third of its kind that I'm aware of in the entire nation. I started prosecuting animal crimes because our Supreme Court Justice, Sean LaGrua, essentially when I started my career as a prosecutor in 2004 after clerking for a judge, she told me that she wanted to start changing the way that we handled animal crime prosecutions in Georgia. She said, we go out here and we arrest people for a lot of things under our laws, but we're allowing people to brutally harm, kill, poison, all kinds of horrible animal abuse and neglect, and yet we don't do a whole lot about it on the state level and on the federal level. As you can imagine, that was back in 2004. I have seen a lot of things change in this state and in this nation as to how we handle animal cruelty cases and animal fighting cases. When I started my career and I was told, I want you to start handling animal crimes, I had no idea what I was doing. I had no idea what that meant. I had no idea how to assist law enforcement with investigating these types of cases. And after almost 20 years of doing this in Georgia, I now spend my full-time job is to assist law enforcement and prosecutors with investigations and prosecutions of these cases, and I also do training across the state and across the nation to train other law enforcement officers and prosecutors how to handle these cases. The reason I got so into it and so interested in it, and the reason I'm so passionate about it 20 years later, because I didn't go to law school to be a prosecutor, but 20 years later, here's what I'm doing in this state. And the reason for that has a lot to do with all of the other different types of crimes that I have seen associated with animal crimes and with animal cruelty cases. What I've seen firsthand in my career in the past 20 years is how linked animal crimes are to gangs, drugs, illegal weapons offenses, human trafficking cases, prostitution, domestic violence, child abuse, elder abuse. And that's why you've seen across the nation, 42 states have made cockfighting, specifically game cockfighting, a felony. In addition to that, possession of the birds for the purpose of game cockfighting is prohibited in 39 states and DC. Being a spectator at a dog fight is illegal in 43 states. And 29 states and the District of Columbia also prohibit possession, manufacturing, and sale of animal fighting paraphernalia. Georgia's one of the first to have a statewide animal crimes prosecutor, and this is my full-time job, yet I do not have a state gamecock fighting law to assist law enforcement to go after these criminals who are coming into what federal law enforcement call the cockfighting corridor. That is what this area is known for. Why is that? Because you can come into the state, you can bring your birds, you can bring your knives, you can bring your gaffs and your illegal drugs and your weapons and all of that, and you can attend these cockfights every other weekend in the state of Georgia, all around rural Georgia, and you can distribute your drugs. You can engage in human trafficking and prostitution and all kinds of other illegal activities. So a lot of people are flocking to Georgia to do that. I've been personally involved in a number of different cases, one of which I want to bring to your attention happened in April of 2021. You can Google this. There's a lot of information about this case out there online, but it was called Operation Dirty Water regarding the Juarez cartel. The major bust ended up occurring in Polk County, Florida. What happened there is a mastermind by the name of Brian Stanton, aka Little B, was behind bars in Atlanta at a federal penitentiary. He was distributing large amounts of liquid meth in orange buckets, those ones that you buy at Home Depot. And when they ended up raiding the location that was connected to him in Polk County, Florida, they found 1,342 pounds of liquid meth, that's 120 gallons, 63 kilos of crystal meth, 25 pounds of THC gummy bears and hard candy, 2,544 Xanax pills with a street value of $54 million. One of those drug traffickers who was transporting drugs for this mastermind out of the Atlanta penitentiary had spent 10 years in a federal prison for drug trafficking. Got released, was on parole from Stone Mountain, Georgia, came up to Georgia and was distributing drugs for this trafficker. This investigation continued to lead them to search warrants that were conducted in College Park in Union City of a member of the Juarez cartel named Isadora, and his last name is escaping me at the moment, but they ended up uncovering a cockfighting operation that he was involved in. At that time, they found 81 pounds of methamphetamine along with a bunch of equipment used to produce it with a street value of about $290,000. A couple years ago, when I got sworn in as a federal prosecutor to handle some of the major cockfighting operations that were going on in Lincoln County and Emmanuel County, some of the first information that we were receiving about these cockfighting operations was that one of the cartel families was trafficking a bunch of drugs through those cockfighting operations. They had been operating in Georgia every other weekend between two different individuals who are now both in federal prison, operating cockfighting operations where people were flocking in from all over the Southeast to come into Georgia to fight the birds here. Hundreds of thousands of dollars coming into this community, along with a lot of birds who, guess what, also carry diseases. One of the things that we had to decide to do when we were conducting that raid was, what are we going to do with the birds? That's one of the ways that I found out how much of a problem it is for Georgia to be allowing these cockfighting operations to occur when our poultry industry is very valuable to us. And what happens is when we allow all these individuals to bring these birds into Georgia to start fighting them, it can also cause major outbreaks with our poultry industry. But let's talk about the one thing that bothers me the most about this, is that first and foremost, some people around Georgia consider this a family affair. They are bringing our children that are going to school with your children, to these cockfighting operations or events on the weekend where they're betting money to watch individuals tie razor blades and or gaffs or knives. They fight two different ways, but they're essentially razor blades of some sort to these roosters' legs, and they fight to the death. I did not even really fathom how disgusting and horrible this is until I started witnessing it firsthand when we were conducting undercover operations before we did this raid. These are children coming to these events, watching roosters tear each other apart. It's a bloodbath. Then they take the roosters that die and they essentially throw them in a burn barrel, alive or not, or some of them are dead, some of them are on their way to being dead. But they basically get gouged by these knives and these gaffs in the eyes and the lungs, and these children are watching these events occur. And we wonder why we have such a rise in school violence these days. We wonder why our children seem desensitized to violence. This is one of those ways. So I'm not really going to come in here and talk to you about the roosters because yes, it's horrible that we're treating roosters this way, but it's about so much more than that. And why Georgia is allowing this to still happen here is a huge problem. Law enforcement officers around the state are begging to be able to use this new law, this new bill, to prosecute and to investigate, arrest people, and for us to prosecute these cases. Not because of the roosters in and of themselves, but because of how connected they are to so many other different types of crimes. I mean, it is a public safety issue much more than it is an issue about a chicken. This is not about chicken. This is not about roosters. When these cartel members are showing up to these cockfighting operations, you're talking about a lot of very serious weapons, a lot of drugs, and then, like I said, children there. And so when you end up with rivaling cartel members that happen to show up at the same cockfighting event, which it's flocking here more and more. Now that Georgia's the one place that doesn't handle this on the state level, we have to have federal involvement. As you can imagine, the federal government is spread very thin. However, we did take down the 3 largest chicken fighting operations in Georgia over the past 2 years. All 3 of them ended up getting federal prison time, and we sought forfeiture of their land. But those were major operators that, like I said, were conducting these operations where a lot of people were turning the other way, knowing that this was occurring in their communities. And that's a huge problem, especially for all of the law enforcement that had to gather together to infiltrate these operations and to take them down. We've talked about the connections to drug trafficking, cartel, illegal weapons. Public corruption is also one of them. We know that is going on as well. That's a problem. Money laundering, we've talked about human trafficking. A lot of times, the human trafficking comes into play in the form of forced servitude to pay gambling debts. Sex trafficking is occurring at these events. There's also cockfighting related assaults, thefts, and even murders that occur because of them. The FBI has now recognized cockfighting as a serious crime. It's included in the NIBRS incident report, the NIBRS-based reporting system that classifies different crimes. It's now classified as a crime against society, which is in the same category now as murder, rape, arson, and child pornography. So what does this bill do? This bill allows somebody like me that assists law enforcement around the state every day, that when I get calls, like I do on a regular basis, about finding yards of roosters and knives and gaffs, and clearly we can identify that these people are raising these roosters and have these knives and gaffs for the purpose of cockfighting, which is required under this law, it's going to allow us to actually arrest these people like they can be arrested in every other state in the United States except for Georgia. What does it not do? Because I think this is just as important. What it does not do is it does not allow somebody like me or law enforcement to go after people who might have old memorabilia from knives or gaffs or something that, was a family member that passed them down to them or something like that. any evidence that I find or that law enforcement finds that has to do with these crimes, we still have to prove that it was with the intent for somebody to engage in gamecock fighting. And I want to make that very clear. So, I mean,
Thank you,
as
Miss.
you guys can imagine, I can talk for quite
If
some
you can
time
wrap
about
it up,
this.
that's what I was going to say,
I
Ms.
could
Roth. Thank
continue
you.
on and on, but what I'll do is open it up for questions and just let me know what I can do to help you all understand why this is so important.
Sure. Thank you for being here. Any questions? We do not have any questions. Thank you for being here. Thank you, Representative Hilton. Do you want to?
Three quick points as I was kind of jotting down here. If you recognize this language, this same bill, same language passed the Senate last year, was introduced late in the session. It was Senate Bill 512, passed on a vote of 49-2, with our now Agriculture Commissioner Tyler Harper voting in favor of the bill. You know, as we've heard repeatedly, we are the #1 state for business. I do not want us to be the #1 state for gamecock fighting. Violence begets violence, and this is something that we need to end here in our state. So I appreciate y'all's consideration.
Thank you.
Thank you.
Chairman Leverett? Does everybody have a copy of Chairman Leverett's bill now? Or not?
Thank you, Madam Chairman. Yeah, so LC 480867S, all 4 pages of it, hopefully now. As Jerry Lee Lewis said, I'll try this one more time with feeling. So we've tried to just concentrate the definitions instead of putting them in 16.1 or putting some other places. We're putting them in the actual statute, which will now be in 6.722. And we're leaving more or less intact the existing language concerning criminal damage to property in the first degree, and still leaving the penalty, the current 1 to 10, to apply to that prong of the statute. But we're adding the damage to critical infrastructure, and we're providing that it is knowingly without authority and by, and I'm reading lines 39, 40, and probably will go on the next page, knowingly without authority and by either force or violence or by electronic means interfering with proper operation of any critical infrastructure or other vital public service. And for that, the penalty would be 2 to 20 years. We're doubling the low end and doubling the high end. And then I think 16.725, I think, is largely the same as it was before. We're just, because we're adding a crime that relates to interfering with critical infrastructure, we're rewording 16.725 so it's clear that just applies basically to when you interfere with it so as to procure for yourself a service for free, like when you tap into your neighbor's cable line or internet line without authorization. And then we did leave the definition of critical infrastructure also appears in the domestic terrorism statute, which is 1611-220. And in section 4, we're using that definition in our new statute on criminal, trespass or damage to property. But we added or any other vital public service to that definition. And so that would apply not only for domestic terrorism, but also to the sort of the, our Bubba scenario crime that Chairman Smith and I have been so fond of trotting out, as we have some cultural familiarity with that kind of behavior. Now, there are a few additional changes that we just kind of came up with before the committee meeting to some of the new definitions. And I would like to propose those to the committee to see if we could get those approved today, if it's your pleasure, Madam Chairwoman, and so that we can actually have a sub with those changes ready for the full committee once it gets ready to attend it. So if I would just try to read those into the record.
Yes, please.
All right, so these changes actually all occur in those 2 definitions of electronic means and vital public service, which occur on page 2 between lines 22 and 34. So we would delete on line 24 intended to or from sort of the middle of that line. So it would read of other technology is intended to or would be deleted, so that successfully modifies, alters, damages, etc. And then continuing, we would delete on line 25 critical infrastructure or that deletes. So from critical to deletes, and then also delete the word transmit And then,
Sorry, what are we, can you say that again?
yeah, I'm sorry, I know these are a lot of changes. So we're deleting the words after destroys on 25, critical infrastructure or that deletes.
Okay.
And then we're also deleting the word transmits. And then we're deleting consumes information within, utilized by, or produced by critical infrastructure and on lines 25 and 26, and replacing that with transmits information. So that would read alters, damages, or destroys records or transmits information which disrupts the normal operations in this period after operation. So we would then delete of critical infrastructure. And then the changes on lines 30 through 33 are a little more compact. On line 30, we would delete after public transportation. We would delete from the and all the way down through line 21 and to the end of line, 31 to the end of line 31. So after public transportation on line 30, delete the rest of that line and delete the entirety of line 31. And then in line 33, we would delete be likely to. And I believe those were the only changes we had. I know that's quite enough, but I think that was it. So we're just trying to avoid referring to a defined term within another defined term, and also just pare down some of the scope to try to address some concerns that were expressed to us. So,
And Chairman, if I can, I'm just going to read just to make sure we have the changes correct.
I welcome that suggestion, Madam
Yeah,
Chair.
so we're starting at line 22. So it says electronic means any unauthorized transmission of fraudulent or unauthorized data, including data that is self-replicating or self-propagating, and any use of other technology that successfully modifies, alters, damages, or destroys records or transmits information which disrupts the normal operation of critical infrastructure.
I think we can just say which disrupts the normal operations, period.
So delete of critical infrastructure on line 27.
That's correct. Yes,
Okay,
ma'am.
so period after operation. And then starting 28, line 28, vital public service includes without limitation water, sewage, drainage, energy, electric, gas, natural gas, telecommunication, internet, cable, and navigation, collision avoidance, public transportation, services provided by or authorized through the state government, and other services, the loss of which would have a debilitating impact on health, safety, or financial security of the public.
Yes, ma'am.
Okay.
And thank you for coming
All
at
right.
it to the positive to say what we'd be including.
Okay. Do you have anything else, Chairman?
I believe that is it, Madam Chairwoman.
Okay. We've got several people that have signed up to hear this. Since this is, I apologize, we actually do we have any questions from the committee? All right. Since we are a little late in the day and we've heard this, I'm going to just limit comments to about 3 minutes. So I'm going to have Jill Travis with Gactyl come up first, please.
We appreciate Chairman Leverett's consideration and changes very much. Thank you.
Thank you, Jill. Robert Smith with PAC.
I signed up this time. If anybody doesn't have any questions, I don't have anything else to say or add.
Oh, Chairman Smith has a question. Sure.
I've got to mess with him real quick. It's about his tie. Robert, just indulge me. Why are you wearing the tie today? Let us know why you're wearing the necktie specifically.
Live on. Oh, good. I got this. I'm going to blow it. The French translation. Let the good times roll. It is Mardi Gras and Fat Tuesday.
That's all I had.
Which I apologize because my daughter speaks French. You know, my family. There's French-speaking people in my family. I can't speak foreign languages.
Thank you. Kevin Curtin with Georgia EMC. Okay, thank you. Okay, do we have any other questions from the committee members? Sure. Representative Byrd?
Thank you, Mr. Chairman. Just want to make sure that as we discussed as yahoos, that they're not going to they will not be sent to prison for life. Would that be correct?
That's correct.
Thank you.
Chairman Smith?
Thank you, Madam Chair. Chairman Leverett, I want to thank you personally for the diligent work you've done on this bill, and I appreciate all the involved parties giving you input. Thank y'all. I know this has been an arduous process, but we want to make sure we get this right. So, Mr. Chairman, I appreciate that. And Madam Chair, at the appropriate time, I'd like to make a motion, move to pass.
We've got one more question, so let me take that. Is that Representative Miller? I'm sorry, Representative Crowe.
Thank you. Just one quick question, and mostly for clarity. On line 30, we were deleting starting after the comma after public transportation. Is that right? Or was a comma coming out too? So it would say public transportation services provided by. That would be what it would say.
I think actually, and I'm sorry, Chairman Leverett, I think you meant to do on line 30, public transportation and then go down to 32 services provided by.
I don't know, let me refer to my brain trust.
Is Robert with his tie? Yeah.
Okay.
So we're taking out the public transit, ambulance, hospital, emergency medical, and emergency rescue services, police, military, prison, and fire. That's it. 'Cause it says fire services, but we didn't take out services. So fire services is usually this. That's why I was questioning whether the services should stay. And I could also ask why we were taking those out of vital public service, but
I didn't realize that was fire services.
I think that's how it was intended to begin with. So I just want to make sure it reads right once we.
I'm sure I think that point's well taken, unless I hear any objection from the folks who have very assiduously been working. Well, Robert has
I think that looking at one of the many drafts that's been exchanged back and forth.
If you can go to the mic, sorry, thank you.
I think the word system is the one that after public transportation that got deleted accidentally. Basically, public transportation, and then Jill had written in systems here, public transportation systems.
That's from 220, if you want to use
Right
that
there.
definition from 220 and bring in so that it's symmetry between the two code sections.
so we'd have systems.
It sounds like we need to, for symmetry purposes, we need to have systems there after public transportation. So it's a public transportation system.
And then you'd have,
System or systems with an S.
I'd have to look at what it is. Well, the idea was to replicate what was in 1611-220, the terminology.
Systems.
And if it's systems there, it would be systems here. And then you'd have one more definition under 16.722, which would say public transportation systems shall have the same meaning as provided in code section 1611-220.
I think, is Mr. Smith looking up that?
Yes, ma'am, I am. Public transportation system with an M, no S. That's the definition found in 1611-220 sub 3 for public transportation system.
So if we read it, right, so starting line 30, we would say avoidance and public transportation system, and then go down to 32, provided by or authorized through the state government.
And to answer Chairman Crow's, Representative Crow's,
Correct.
the comma would be removed.
And we'll add an and to between avoidance and public transportation system on line 30.
Yes, okay, sorry.
Does that make sense? Correct. Okay. I think we got it. Thank you all for working together on that.
Thank you for the opportunity.
Yes, of course. Any other questions? Chairman Smith, did you have I'll take up any motions.
I move that we pass this with the edits that were agreed to just now. Move that we pass this out of sub to full.
Any second? Second. Okay. And all in favor, say aye. Aye. Anyone opposed, say aye. Okay, it will pass our committee. Thank you, Chairman Leverett. And that concludes our meeting. Thank you.